Hello everybody, I am Dr. Bharti, working as an Assistant Professor of Law at National Law University, Delhi. Today I will be discussing a module on appreciation of evidence. The objective of this module is to understand the basic concept of appreciation of evidence, to know the fundamental principles of appreciation of evidence, to understand the rules of appreciation of evidence relating to admission, confession, FIRs, statement recorded by police, discovery statement, circumstantial evidences and electronic evidences. In a criminal case, court determines the guilt of an accused person on the basis of evidences produced before it. Indian Evidence Act provides that the fact on which evidences can be produced before it. Once the evidence is proved, then comes the question of evidentiary value of the evidence produced before it. If the evidentiary value of the evidences available against the accused is strong enough to prove the guilt of an accused person beyond reasonable doubt, then only he can be convicted. First of all, we need to understand what are the type of evidence recognized under Indian Evidence Act. Evidence can be in documentary form or in the oral form. Documentary evidence include electronic evidence as well. Section 5 of the Evidence Act also describes that evidences can be given only on fact and issue or relevant fact. After understanding the type of evidences and the facts on which evidences are permitted to be produced before court, now we need to move ahead to understand the basic rules of Evidence Act. There are certain basic rules which are taken into consideration by the court for the appreciation of evidence. One of such rule is guilt of an accused person should be proved beyond reasonable doubt. Second rule is rule of proof. Whenever evidence is produced before the court, if court, after taking into consideration all the evidences before it, considers it to exist, or a man of ordinary prudence would act under supposition that it exists, then only it is said to be produced and proved before the court of law. A fact is said to be disproved when, after considering all the facts before it, court believes it to not exist, or a man of ordinary prudence would act under a supposition that it does not exist. In all the cases, court doesn't ask for the direct evidences or evidences to prove a matter in issue. There is another rule which is applicable for the appreciation of evidence, which is rule of presumption. Indian Evidence Act has laid down the rule of presumption, which provides that in certain circumstances, court presumes a fact to exist. There are different degrees of presumption: shall presume, may presume, and conclusive proof. If a fact falls in the may presumption category, then it is in the discretion of the court to believe it or not to believe it, but other party has every right to produce contradictory evidence to rebut it. If a fact falls in shall presumption category, then it is mandatory on the court to believe it, and court will not ask for further evidences to disprove it, but the other party has every right to produce evidences to disprove it. If a fact falls in the category of conclusive proof, then if a fact which is a primary fact which has been proved beyond reasonable doubt, then it will lead to an inference of the conclusive proof of another fact which is dependent on them. And in that case, if a fact is of conclusive nature, no evidences will be called by a court, and the other party will also be not allowed to produce evidences to disprove it. Another rule of evidence is falsus in uno, falsus in omnibus, which means if a fact is false in one circumstance, then it will be false in all other respects. But this principle is not applicable in India as a rule of law. It is only a rule of prudence. So it is in the discretion of the court to rely on a part of a fact and reject rest of the part of a fact. Another very important rule of evidence is best evidence rule. It says if any fact has been reduced to a form of a document, then a fact and the terms and conditions and the content of a document can only be proved by the production of document itself. Oral evidence as to content of document cannot be allowed at the first instance, subject to certain exceptions. After understanding the basic rule of Evidence Act, we need to move ahead to understand the basic rules of appreciation of evidence. Statute like Indian Evidence Act and the Code of Criminal Procedure provides the evidentiary value of different evidences which are allowed to produce before court. There are certain cases and certain evidences regarding which such statutes are silent regarding the evidentiary value. Then the judiciary steps in and clarify the position and expressly lay down the evidentiary value of such evidences whose evidentiary value has not been specified by the statute. But such ruling of the court are not universal in application. It depends on the facts and circumstances of the case. Judiciary has been given ample discretion to do justice with the case pending before it. Once it is clear to us that what are the basic rules of Evidence Act and the basic rules of appreciation of evidence, now we will pick up individual evidences which are permitted to be produced before the court as per the provision of the Evidence Act. One of such evidence is admission. First of all, we need to understand what does admission means. Admission is a statement which can be written on oral and it is made by a party to a suit or their agent or representative or a person from whom parties to suit derive their interest or any other person whose position is relevant or any person who has been referred for the information. It is a statement which draws some inference regarding a fact and issue or relevant fact. Once it is clear to us that what does admission means, let's move ahead to understand what is the evidentiary value of the admission. Section 31 of the Indian Evidence Act deals with the evidentiary value of the admission. It says it is not conclusive but may operate as an estoppel. It means when a person admits something, then he has every right to rebut his statement by saying that he made it under a mistake of fact or under some influence. But if the admission has been relied on by another party and he has changed his position on the reliance of the admission made by the party, then after that he cannot change his statement. So it cannot be the conclusive proof in that situation. Next piece of evidence is a confession. Confession has not been defined under the Indian Evidence Act. In the case of Palwinder Court versus State of Punjab, the court has defined the confession. It is provided that confession must either the term of the offence or at any substantial rate all the fact which constitute an offence. It means either a person says that I committed a theft, or he may say that he with dishonest intention without the permission of the owner dishonestly moves the car of another person. In this way, he has accepted all the ingredients which constitute an offence instead of saying that yes, I committed a theft, which means either the accused person accept the commission of an offence by the term with which it is defined under a substantive law or accept to commit all those ingredients which constitute an offence. Now we will move ahead to understand the evidentiary value of the confession. Confession is of different kind. First of its kind is a judicial confession. Judicial confession is a confession made to a magistrate. It can be made during investigation under section 164 or during the trial once the charges have been framed. It is the most reliable piece of evidence and it can be the sole base of conviction. Another type of confession is an extrajudicial confession. It is a confession which is made to a person other than a magistrate. It is a weak type of evidence and it can be a sole piece of conviction provided it is proved that it was made voluntarily by a person. Another type of confession is a retracted confession. Confession which was made before the trial begins and it has been retracted by its maker after the trial has begun. It is a very weak piece of evidence. It cannot be a sole piece of conviction until and unless it has been proved that it was made voluntarily and has been substantially corroborated by material evidences. The same position was laid down in the case of Sakharam versus State of Maharashtra, in which case it was laid down that retracted confession is a very weak piece of evidence and it can be relied on only if it is proved that it was made voluntarily and has been substantially corroborated by the material particulars. Another type of confession is a confession of co-accused. Section 30 deals with such type of evidences. It says that if more than one person have been jointly tried for the same offence and one of the accused makes a confession affecting himself and another accused, then confession regarding another accused can be taken into consideration, which means it can only be taken into consideration and it cannot be the sole ground of conviction. It has only corroborative value. Another piece of evidence which we need to look into is the evidential value of confession to police. As per section 25 of the Indian Evidence Act, confession of police cannot be proved because then there is a doubt that police might have extracted the confession by torturing the accused person. So it is not admissible as per the provision of the Evidence Act. But confession in the police custody was recorded in the immediate presence of the magistrate, then it can be proved as per section 26 of the Evidence Act. And in that case, it will have that evidentiary value which is attached to a confession made to a magistrate. Next piece of evidence is the evidential value of a discovery statement. If an accused person is in police custody and he deposes, and on the basis of the deposition, which may be in the form of confession or not, some discovery have been made by a police, then only that part of the statement which led to the discovery can be taken into consideration and can be proved. But again, it is not a substantial piece of evidence, it has only corroborative value. Next piece of evidence which we will discuss is evidentiary value of FIR. It is not a substantial piece of evidence, it has corroborative value under section 157 of Indian Evidence Act. It has also contradictory value under section 145 of the Indian Evidence Act. It can also be used as a conduct under section 8 of the Indian Evidence Act. If a person goes to a police officer and makes a complaint, then very act of making a complaint is a conduct relevant under section 8. It can also be used as an admission under section 21 of the Indian Evidence Act. In addition to this, if the accused person at the time of making an FIR is in the police custody and it has led to the discovery of a thing, then it can also be used under section 27 as a discovery statement. Next type of evidence which we need to discuss is evidentiary value of confessional FIR. When accused makes an FIR, that is, give first information of the commission of offence to police and state that he has committed an offence, it is known as confessional FIR. If the accused is in police custody while making confessional FIR, then confessional part of the FIR cannot be proved as per the provision of section 25, which says confession to police cannot be used and proved. Only non-confessional part of FIR, if it leads to discovery, can be used under section 27 of the Indian Evidence Act. If the accused was not in police custody at the time of making of the confessional FIR, then confessional part of FIR cannot be proved as per section 25 of the Indian Evidence Act, but whole of the non-confessional part may be proved against him. But it has only corroborative value and it cannot be the sole piece of conviction. Evidentiary value of confessional FIR can be better understood with the help of an illustration. I killed deceased with knife because I wanted to take revenge from him for defaming me, and I have hidden the knife from which I killed him in the backyard. If the accused person while making this statement was in police custody, then only I have hidden the knife in the backyard may be proved with discovery of knife from the backyard. If an accused person was not in police custody while making a confessional FIR, then the part of his statement which state that I wanted to take revenge will be relevant under section 8 as a motive of commission of an offence, and act of making complaint would also be relevant as a part of section 8 which state that conduct of an accused person is relevant. Discovery would not be relevant in this case because when an accused person makes this statement, he was not in police custody, and for making a statement relevant under section 27 which deals with discovery statement, it is mandatory the person must be in the police custody. Next piece of evidence which we will discuss is a statement recorded by a police under section 161. As per section 162, such statement cannot be used, but it has 3 exceptions to it. First exception is it can be used for the purpose of contradiction as per the provision of section 145. Another exception is if it leads to discovery and fulfill the ingredient of section 27, which we have already discussed, then it can be relevant under section 27. Third exception is if a person making that statement is dead, then it can be used as his dying declaration if it fulfills the ingredient of dying declaration as defined under section 32 of the Indian Evidence Act. Next piece of evidence is dying declaration. It is dealt with under section 32 of the Indian Evidence Act. It's a statement as to cause of a death or the circumstances which led to his death. It is an exception to general rule that only oral evidence must be direct, as it is not an oath and there is no scope of cross-examination because the person who made the statement is dead and is no more available for making a statement again before the court on oath and subject himself for cross-examination. After question, court seek corroboration from other circumstances, but it can be the sole piece of conviction. It has a stronger evidentiary value. Next point which we need to understand is what will be the evidentiary value of a dying declaration if its maker survives. Dying declaration to magistrate can be used if its maker survives for the purpose of corroboration under section 157 or contradiction under section 145. Dying declaration to police, if its maker survives, can't be used for the purpose of corroboration as per the bar of section 162, but it can be used for corroboration under section 145 as it is an exception to section 162 CRPC. Next type of evidence which we will look into is the expert evidence. When court has to form an opinion on foreign law, science, art, or as to the identity of handwriting or finger impression, opinion of person having special means of knowledge is relevant as per the provision of section 45 of the Indian Evidence Act. The evidentiary value of expert opinion is not conclusive, it has only corroborative value. Next type of evidence which we will look into is a circumstantial evidence. It is a direct evidence. It is not to be confused with hearsay or secondary evidence. It is generally used when no eyewitness is available. It can be the sole basis of conviction provided circumstances from which the conclusion of a guilt is to be drawn should be fully established. The facts so established should be consistent with the hypothesis of the guilt of the accused. Circumstances should be of conclusive nature. They should exclude every possible hypothesis except the one to be proved. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused and must show that in all human probability the act must have been done by the accused. The next piece of evidence which we need to look into is the electronic evidences. The issue of admissibility of electronic evidence came before the Supreme Court way back in 1975 before the Information Technology Act 2000 or the Prevention of Corruption Act came into being. The issue in controversy was whether telephonic recording, conversation or evidences such as phone tapping were admissible or not. The judgment pronounced by a constitutional bench of Honorable Apex Court in the matter of S. Pratap Singh versus State of Punjab categorically laid down the proposition that telephonic evidence or phone tapping cassette, which were a type of electronic evidence, were very much admissible as evidence in the court of law. The mere possibility that they were susceptible to tampering could not be the ground of rejection of such type of electronic evidences. It was further held that they are in the nature of primary evidences and therefore admissible. The court also laid down elaborate rules for the admissibility of electronic evidences. It was later, on account of growing need of such electronic evidences, section 22A, 45A, 59, 65A and 65B of the Indian Evidence Act were incorporated to deal with the issue of admissibility of electronic evidences. With the inception of the Information Technology Act and its subsequent amendments in the year 2005, a host of new offences have come into being as a cyber offences which require different standard of proof. The nature of evidence required to prove electronic document is a substantial departure from the traditional way of appreciation and leading of such evidences. It is on account of above mentioned infirmities that the legislature amended the Indian Evidence Act to include the admissibility of every electronic evidence, which may include and is not restricted to floppy, hard disk, etc. The Supreme Court, in the recent case of Ansar PV versus PK Bashir and another, clarified the position of electronic evidence in the Indian Evidence Act. In this case, it has been clearly laid down that how an electronic evidence can be proved, in what circumstances secondary evidence can be given, and what amounts to electronic evidences. Any electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under section 65B. Section 65B deals with the admissibility of electronic record. The purpose of these provisions is to sanctify secondary evidence in electronic form generated by a computer. It may be noted that the sections start with a non-abstentive clause, which means notwithstanding anything else contained in any of the provision of this Act or any other Act. It gives exclusive nature to these provisions, which means electronic evidence can be proved only as provided under section 65B. The very admissibility of such a document, that is electronic record, which is called as a computer output, depend on the satisfaction of 4 conditions laid down under section 65B subclause 2. So, if these conditions have been complied with and fulfilled, then an electronic record is termed as an electronic record sufficient enough to be produced before the court. The conditions are: the electronic record containing the information should have been produced by the computer during the period over which the same was regularly used to store or process information for the purpose of any such activity regularly carried on over the period by the person having lawful control over the use of that computer. The information of the kind contained in electronic record or of the kind form from which the information is derived was regularly fed into the computer in the ordinary course of business. Third condition and the requirement is: during the material part of the said period, the computer was operating properly, and that even if it was not operating properly for some time, the break and the breaks had not affected either the record or the accuracy of its content. And the last condition is: the information contained in the record should be a reproduce or the derivation from the information fed into the computer in the ordinary course of said activity. Once these conditions and the terms are complied with, the output of that computer is termed as electronic output. For producing it before the court and for its admissibility, there are certain conditions which are laid down under section 65B subclause 4, which state that there must be a certificate which identifies the electronic record containing the statement. The certificate must describe the manner in which the electronic record was produced. Third point is: the certificate must furnish the particulars of the device involved in the production of that record. Another condition is: the certificate must deal with the condition laid down under subclause 2. It means it must qualify to be an electronic output admissible before the court as laid down under subclause 2 of section 65B. Last condition is: the certificate must be signed by a person occupying a responsible official position in relation to the operation of the relevant device. It is further clarified the person need not only to state in the certificate that the same is to the best of his knowledge and belief. The most important, such a certificate must accompany the electronic record like computer printout, compact disc, video compact disc, pen drive, etc., pertaining to which statement is sought to be given in evidence when the same is produced before the court of law. All these safeguards are taken to ensure the source and authenticity, which are the two hallmarks pertaining to electronic record sought to produce and prove before the court of law. Electronic records being more susceptible to tempering, alteration, transposition, exclusion, etc. Without such safeguard, the whole trial based on proof of electronic record can lead to injustice. Once it is proved before the court that the electronic record produced before the court is the one which is admissible as per the provision of section 65B subclause 2, and it is accompanied by a certificate fulfilling all the requirement as laid down under subclause 4 of section 65B, if there comes the question of genuineness of the document which is an electronic record, then recourse can be made to section 45A, which says resort can be made to opinion of expert who can be the examiner of electronic evidence as to provide its expert opinion regarding the authenticity of the original produced before the court. Another section which is relevant here is section 22A, which says that oral admission as to the content of electronic records are relevant if the genuineness of the electronic record are in question. To conclude, I would like to say that rules of appreciation of evidence have been clearly laid down under statutes like Indian Evidence Act and the Code of Criminal Procedure, and whenever such statutes are silent, the judiciary has stepped in to clarify the position and to clarify the evidentiary value of the evidence whose evidentiary value has not been clearly laid down by such statute. But we need to understand, and also we need to be clear on this point, that these rules and regulation laid down by judiciary are not universal in application, and they need to be applied looking into facts and circumstances of the case pending before the court. So, judiciary has been given adequate discretion to do justice with the case pending before it in the light of the expression provision of the statute and the judicial pronouncement which can be applied and adopted in the case pending before it. Thank you.